A lawsuit blames the Rhinelander paper mill's parent company and a chemical manufacturer for PFAS contamination in rural Oneida County.
Last week, a motion filed by 3M to move the case to South Carolina was denied, and the case will stay in Wisconsin. Our own Jake Force has been following this story and has more. Jake?
That's right. The lawsuit filed in August alleged that the Rhinelander paper mill, owned by the Swedish energy company Alstom-Munksjö, applied toxic waste-containing PFAS chemicals onto farmland across Oneida County that contaminated the well water of many of these residents. These chemicals were made by 3M Company, who is also a defendant in this lawsuit. This week, a panel of U.S. district judges ruled to keep the case in Wisconsin.
The Texas-based law firm Barron & Budd filed a class action lawsuit in August against Alstom Rhinelander LLC and 3M Company for PFAS contamination on farmland in Oneida County. 3M then filed a motion to move the case to South Carolina. The motion was denied last week by the United States Judicial Panel on multi-district litigation.
Keeping the litigation in Wisconsin will allow us to start discovery to better understand more details about what led to the contamination of our plant's wells.
3M wanted to move the case to be litigated with other PFAS-related cases being processed in South Carolina, a practice known as multi-district litigation. But those lawsuits focus on aqueous film-forming foams, or AFFF, which have been used to fight fires at airports. The lead attorney for the plaintiffs, Brett Land, said the case concerns the spreading of paper mill sludge, so moving the case didn't make sense.
If the case would have been transferred to that NDL, it would have been a lot longer before we could have engaged in active litigation on this case. And we want to get moving. And so the best way to do that is to keep the case in Wisconsin and keep litigation going.
Court documents showed that 3M argued that AFFF contamination of well water at Rhinelander Oneida County Airport would cause for overlapping discovery in the case. But in the ruling last week, the judicial panel ruled that 3M did not meet a, quote, significant burden, unquote, of showing that the transfer was necessary. Land said this will help the case advance in a timelier manner.
You know, our case really doesn't relate to this AFFF, the firefighting foam. So our case really doesn't belong there. And then in addition, of course, we want to move this litigation along. And if we're in the MDL, we would not have been able to do that.
3M told Newswatch 12 today in an email they stand by the motion, adding, quote, 3M will continue to address PFAS litigation by defending itself in court through negotiated resolutions as all as appropriate, unquote.